Senate Judiciary Committee will come to order. And it is likely our last meeting of the session because non-exempt committees, which Judiciary is a non-exempt committee, our last day to meet is tomorrow, and we're planning on getting all our work done today. And not only is it then our last meeting today of the session, but we have a kind of a personal point of privilege from Senator Olson.
Thank you, Madam Chair. 20 years ago, I started this, and I figured up it was 3,500 plus meetings I've sat in these committee meetings over the years. I think Jason was in my class, and you know, it's a long time, a lot of meetings. Learned a lot of stuff about our state, and this will be my last. So I appreciate everybody that's here. Former Speaker O'Neill and all the people I've served with. Some I've watched lobby and come to our side of the aisle, and some come from our side of the aisle and go to lobby and staff. And it's been an enjoyment of my life. So thank you.
Well, thank you, Senator. If we'll give him a round of applause real quick. So appreciate your service to the state. Thank you. With that committee, then, we have 8 bills we're going to work. And our first item on the agenda for working bills is we're going to work or seek final action on House Bill 2605. And committee, if you remember, that's regarding bids pay. And with a brief reminder from the reviser.
Thank you, Madam Chair. Jason Thompson, Office of Reviser of Statutes. You're correct. House Bill 2605 is the one that increases the maximum rate paid to appointed counsel for indigent persons by the Board of Indigent Defense Services. The current rate in statute is $80 per hour with some exceptions, and the bill increases that to a rate not less than $120 per hour and not more than $140 per hour.
Thank you. Committee, any questions for the reviser? Not seeing any, then is there a motion? Senator Olson.
Thank you, Madam Chair. I move that we pass House Bill 2605 favorable for passage.
Is there a second? Senator Bowers, any discussion? Committee, it is of a rather, I think, non-controversial nature. So is it something that we want to consider putting on the consent calendar? And I'll ask the maker of the motion.
Yeah, I'm sorry, Madam Chair. I didn't think about that. I always like carrying bills, but this is a very non-controversial bill, so I'll rescind my motion. And my motion will be, I move that we pass House Bill 2605 out, favorable for passage, and put it on the consent calendar.
And we have a second on that substitute motion. Thank you from Senator Bowers, who withdrew her second and resubmitted the second on the substitute motion. Well, thank you. You all have heard the motion. All those in favor signify by saying aye. Aye. All those opposed, no. The motion carries. Next, we are going to work House Bill 2781 regarding the Crime Victims Compensation Board. And with that, then, a brief reminder from the reviser.
Thank you again, Madam Chair. Jason Thompson, Revisor's Office. 2781 is the bill brought to you by the Attorney General's Office relating to the Crime Victims Compensation Board. A couple of the highlights would be allowing reimbursement to victims of more than just mental health expenses, but the other expenses allowed by the statute. Also extending the statute of limitations essentially from 2 years to 5 years in many cases, and clarifying that the longer time limit that applies to you can be used so that you have longer to file your claim as a victim. And finally, increasing the rate of the per week or actual loss rate from $400 to $800, and providing a specific statutory amount of $350 to $800 for human trafficking victims to quantify their economic loss.
Thank you. Committee, any questions for the revisor? Not seeing any, then do we have any discussion or a motion? Senator Wilborn.
Madam Chairman, I would like to move that we pass House Bill 2781 favorably for passage, and I think possibly it could be a consent calendar item also. So I'll include that in the motion.
Thank you. And a second from Senator Olson. Committee, any discussion? Not seeing any, then you all have heard the motion. All those in favor signify by saying aye.
Aye.
Those opposed, no. The motion carries. Next, we will work House Bill 2353, and that is concerning assisted outpatient treatment. And with that, then, a reminder from the revisor.
Thank you again, Madam Chair. Jason Thompson, Revisor's Office. And as you mentioned, one of the aspects of 2353 is AOT, the outpatient treatment. The rest of the changes in the bill deal with extending the time limit on ex parte orders of various kinds from the second day the court is open to the third in most cases. Section 3 is a lot of the changes about the AOT program and accommodating that in statute. And the final piece that we discussed briefly that I wanted to remind the committee is in Section 4, there's an extension of orders for continued treatment that's 3 months under current law, and we become 6 months under the bill.
Thank you. Committee, any questions for the revisor? Not seeing any, then is there any discussion or a motion? Senator Bowers.
Thank you, Madam Chair. I would make a motion to move out favorably 2353 and also place it on the consent calendar.
A second from Senator Olson. And committee, this probably is a pretty new concept for the Senate to be learning about, the assisted outpatient treatment program. So perhaps this is something that might not be, it might be worthy to have the discussion. Senator Bowers.
As you said that, Madam Chair, I would rescind my motion, make a new motion to pass out favorably House Bill 2353.
Thank you. And Senator Olson, do you likewise withdraw your second and submit a second on the substitute motion? Excellent. Thank you. Committee, any discussion? Not seeing any, then you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. Does anyone want their no recorded? Senator Stephan. Thank you. Committee, next we will work House Bill 2601 regarding a third or more conviction for DUI and some treatment related to that. With that, a reminder from the revisor. House Bill 2601.
Thank you, Madam Chair. Jason Thompson, Revisor's Office again. 2601 makes one change that was not made when the legislature moved DUI from a non-grid felony that was served in jail to a grid level 6 felony, which is served in Department of Corrections. And that change is to move the multidisciplinary model of services for substance abuse disorders to treat those offenders that are third or fourth time offenders if they're on probation. So if they go to DOC as a imprisonment, this is not an option for them. But if they're on probation, they would receive the same multidisciplinary services that third-time offenders receive in the community.
Thank you. Are these new multidisciplinary services provided for this type of offense? Question for the revisor.
Thank you, Madam Chair. Jason Thompson again. So yes, and I gave a little bit of this yesterday and I was trying to not do it today, but I'll go through it real quick. So if you're a first-time offender or a second-time offender, you receive a special assessment and you have to follow certain treatment recommendations unless the court orders otherwise. If you're a third-time offender, but you don't have a previous conviction in the previous 10 years, you are a non-grid felon and you serve any jail time locally in the county jail, and you receive this multidisciplinary services. And that's what used to happen for all felons under this statute. But if you're a third-time offender with a conviction in the previous 10 years, you're actually a severity level 6 non-person felon rather than a non-grid felon. And if you're a fourth or subsequent offender, you're also a severity level 6 on-grid felon. Those two folks that are on-grid felons do not receive the multidisciplinary model because they're sentenced to DOC custody or probation. But the bill says they would receive that same treatment that the third-time offenders who are not on-grid felons are receiving. So it's just expanding a similar treatment model for those folks that used to get it before the change by the legislature a few years ago.
Thank you. Committee, any questions for the revisor? Not seeing any, then is there any discussion, or I will entertain a motion? Senator Wilborn.
Madam Chair, I move that we move House Bill 2601 as amended out favorable for passage.
I don't think we amended it.
Oh, excuse me. I thought I hit. I'll modify that motion. I move that we move House Bill 2601 favorable for passage.
Thank you. Is there a second? A second from Senator Corson. Any discussion? Then all those in favor signify by saying aye. Aye. Those opposed, no. The motion carries. Next, we will work a bill that we heard yesterday, House Bill 2755, regarding bail bonds. And with that, then, a brief reminder from the revisor.
Thank you again, Madam Chair. Jason Thompson, Revisor's Office. 2755.
Yes, sir.
Thank you. Have my files in order, just wanted to make sure. This is, as you mentioned, the one about appearance bonds. There are essentially two parts to the bill. One deals with municipal courts and some new provisions that deal with appearance bonds in municipal court, as well as setting the bond in an amount that's the same regardless of the method used to serve the appearance, to secure the appearance, of the accused person. And then the other changes are to the district court municipal to the district court bond process, and those require a minimum bond premium amount and also have a lot of provisions for suspension or termination of compensated sureties, as well as fingerprinting of those sureties if the district court orders that.
Thank you. Committee, questions for the revisor? Not seeing any, then I do have an amendment. Thank you. Thank you for sharing that with committee. And you'll recall yesterday that we heard testimony from proponents and opponents on the bill, and that was from the Bail Bonds Association, and we also heard opposition then from the municipal court judges. And after the hearing, there was some discussion between both of those proponents and opponents, the Bail Bonds Association, as well as the municipal court judges, and they were able to reach agreement and a compromise. And that is the amendment in front of you. You'll see that it strikes the language on page 1 that was in the bill and returns it to current law regarding the requirement that the amount of appearance bond shall be the same regardless of the method used to secure the appearance of the person. So I want to ask the reviser for an explanation just to make sure that I've got that correct. Thank you.
Thank you, Madam Chair. Jason Thompson again, Revisor's Office. And no, you're correct. It just strikes the language requiring the amount to be the same regardless of the method used to secure. Strikes in lines 13 through 15. That's all.
Thank you. And I will ask if there's any discussion. Yes, Senator Stephan.
Thank you. Was the municipal judge who was here yesterday, was she involved in the negotiation and agreement of this?
Was the judge who testified yesterday involved? Yes. Judge McElhaney, I think is.
She was in agreement?
She was, yes, sir.
Thank you.
Thank you. And then Senator Olson.
Yeah, thank you, Madam Chair. I really appreciate this amendment because I was probably going to vote no on this bill. But with this amendment, the judge, she's from my local area, very well respected. And I do agree with her on this piece. So by fixing this, I can vote for this bill. So I urge the body to support the amendment. I think it helps everybody.
Thank you. Senator Gossage.
I was just prepared to second your motion on the amendment, Madam Chair.
Okay, great. Well, I will move the amendment then if there are no other discussions, and a second from Senator Gossage. Any further discussion on the motion? Not seeing any, then all those in favor of amending House Bill 2755 with the amendment in front of you, those in favor signify by saying aye. Aye. Those opposed, no. The motion carries. We are back on the bill. Committee, any further discussion? Senator Gossage.
Again, I just want to echo what Senator Olson said, and you had mentioned, always helps us when we're working on bills to have the parties come together and make our job easier with coming up with a compromise. So that being said, I would move that we pass House Bill 2755 as amended favorably for passage.
Second from Senator Olson. And I want to, before we vote on the motion, do want to thank the conferees who were in committee yesterday and their representatives as well for coming together and working out an agreement and a compromise. That is something that this committee appreciates, and I think you'll find that the legislature appreciates. So thank you for your continued work in that regard. Then you all have heard the motion. All those in favor signify by saying yes. Sorry, discussion on the motion. Senator Corson.
Thank you, Madam Chair. I as well appreciate the amendment. And I think it makes the bill a lot better. I am at this point still going to be a no on the bill, and the reason is they didn't testify in person, but there was written testimony from the pretrial justice task force that kind of caught my attention. I feel like I still need to kick the tires on this legislation a little bit. But my reasoning for now at this point is this bill was really brought to us by the bail bond industry, which is fine and that's appropriate. But it was really kind of an industry bill. And my perception, at least at this point, is that part of the motivation for bringing this bill is that they don't like the increased competition in their industry. So they're coming to the legislature and saying, we actually want you to enact essentially state law, state legislative protections that protect incumbents in this industry. And again, I want to learn more, but at this point, I'm just not entirely comfortable with us kind of getting involved in what the bail bond industry is a private industry. There's competition in it, just like there is in any other private industry. And I think, again, what this legislation does is it's sort of incumbent protection of folks who are in that industry. And that's why they brought this bill to us, to help protect their business from new competitors. And so I at this point, a little bit uncomfortable with our legislative role in this. So I'm going to be a no. I'm open to learning more and changing my mind, but at this point, I'm just not comfortable given what was presented to us from the attorney members of the Kansas Pretrial Justice Task Force. So thank you.
Thank you. Committee, further discussion. Senator Steffen.
Thank you. Senator Corson articulated my thoughts precisely, and I'm grateful for that. And I'm going to vote no as well for the exact same reasons.
Thank you. Committee, further discussion. Senator Haley.
I share the concerns of Senator Corson and what he articulated. The industry is coming here for a fix to help supplement their declined revenue. However, this is going to conference. Should this survive the committee process and actually be heard, if it gets above the line, then it's going to conference. And should this, or as this advances, I did note that the House was split on it. I think we had 49 or 50 no votes on this in its current form. So making it better or trying to move it closer from an industry that is seeking legislative relief from its declining revenues is something that can be or will be debated in conference should this survive the committee of the whole. And so I'm pretty neutral on it. I don't want to be the one vote that helps get it out of committee, but certainly I do think we can move the process along with a favorable amendment, with the favorable amendment that's been added.
Thank you. Committee, further discussion. So the bill is now different than it was in the House because we do have an amendment that did get onto the bill and probably addresses some of the concerns that the House had. It passed favorably out of the House. And I hadn't, well, I'll just leave it at that. The vote, I think, was 69 to 40, 69 to 49 on that. So, okay. Any further discussion? We want to make sure that we've heard all the discussion and appreciate that. So with that, then, you all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. No. The motion carries. And division has been requested, so we'll do division. All those in favor, please raise your hand. Thank you. All those opposed? I see 4 hands each, and so the chair will say that we do have a compromise at this point that's been negotiated by what we saw were the opponents and the proponents of the bill, and would appreciate some further discussion, some further action on the bill, and we can do that by advancing the bill. So the chair will vote aye. Thank you, committee. And we will then, and the motion passes. We will then move on to working House Bill 2583 regarding service dogs in service of law enforcement. With that, then, a brief reminder from the reviser.
Thank you, Madam Chair. Jason Thompson, Revisor's Office again. You're correct. This is the bill about harming or killing certain dogs and horses and requiring restitution for those offenses. Section 1 is the amendment to the crime of inflicting harm, disability, or death to a police dog, arson dog, etc. One amendment is to include police horses in the crime. The other amendment is to increase the penalties when a police dog is harmed and it results in disability or death, and it does not result in disability or death. It is a level 4 non-person felony. Back up. Preserves the current law when it does not result in disability or death. Increases the penalty when it does result in disability or death to a level 4 non-person felony. And if it results in disability or death, while committed during the commission of attempting to flee and elude, interference with law enforcement, escape from custody, etc. It's a level 3 non-person felony. And then the last piece is restitution for animals that are killed. Special restitution provisions that include essentially training costs, expenses, boarding, training, etc. That's probably it.
Committee, any questions for the revisor? Not seeing any, then I do have an amendment.
Thank you.
And we'll ask for an explanation from the revisor.
Thank you, Madam Chair. So you'll see on page 2, the amendment is to strike 2 provisions. As I mentioned, police horses are added to the bill. And so we would make a change in both police dog and police horse in this amendment. And essentially, it just expands the definition to include any dog that is owned or the service of which is employed by a law enforcement agency, rather than requiring specifically like detection of criminal activity, enforcement of laws, and my understanding is that this would cover all of the dogs that are used by, say, the sheriff's office that came to testify, that might be used as like community interaction dogs or therapy dogs, but they still work for law enforcement. And that's the idea behind this for both the dogs and the horses.
Thank you. And this was an amendment that was brought to us by law enforcement to clarify what assistance dog means. So any questions for the revisor? Any discussion or a motion? I will move that we amend House Bill 2583 by changing the definition of assistance dog as indicated in the definitions of police dog and police horse amendment in front of you. Is there a second? Senator Bowers. Any discussion? Not seeing any. You all have heard the motion. All those in favor signify. Sorry, Senator Haley. There is some discussion.
Thank you so much, Madam Chair. And just very briefly, do you have any idea what this opening penumbra would mean for the additional dogs as to what those costs will be? My concern with the underlying bill is the whole restitution part. So, I mean, is there any idea or any idea of what opening this up or expansion of this would include? I mean, service animals, as we know, some people use service in a very broad way. For what that service animal for a department would look like, for a police department would look like. So those are my concerns, or the costs of this. And this is kind of on the fly. I realize I don't want to bog down the process, but that's my continuing concern with the amendment and now, of course, with the underlying bill. Thank you.
Thank you. And a question for the revisor. Assistance dog, as defined in current law 39-1113, as also indicated in the bill, that includes private persons therapy dogs as well?
Madam Chair, Jason Thompson. Yes, and so the discussion about the amendment was there are dogs that would be considered assistance dogs who work for law enforcement. So how do we handle that? If you want them to be covered as law enforcement dogs, the simple answer is to expand the purposes that police dogs can be used, right? Not just detection of crime, but any purpose, the service of which is employed by a law enforcement agency, rather than trying to carve out specific dogs that might work for law enforcement. The idea was to make clear assistance dogs are one thing. They have a penalty under current law, but if they're in the service of law enforcement, they're treated differently under this amendment, if that helps to clarify.
Is it already prohibited in law then for regarding assistance dogs not in the employ of law enforcement?
Madam Chair, Jason Thompson again. Yes. So current law says it is unlawful to inflict harm, disability, or death to any of these kinds of dogs, including assistance dogs. And the bill maintains the current law penalties for that, for those assistance dogs, but increases the penalties for the law enforcement, the police dogs, to use the proper term from the bill, police dogs.
Thank you. Any other questions for the reviser or discussion? You all have heard the motion. All those in favor signify by saying aye.
Aye.
Those opposed, no. The motion carries. We are now going to look at House Bill 2665. I'm sorry, we got to move it out of committee. Sorry, I've got my list here, and we'll hold just a moment. Committee, thank you for standing at ease for a minute. We do have another amendment. This amendment is a further clarification brought to us by law enforcement, and we'll wait for an explanation from the reviser.
All right. Thank you, Madam Chair. Jason Thompson, Revisor's Office again. And as you mentioned, in consultation with law enforcement about the penalty provisions, our office noticed it was unclear what the penalty was in this newly structured bill for the base violation we were just talking about. So if you inflict harm, disability, or death to any of these animals, the amendments kind of didn't make it clear that that remained a non-person felony, just as it is in current law. So that's the first change, is to sort of restructure the penalty provision in B so that it's clear in B1, violation of subsection A is a non-person felony, just like it is under current law. And then further, B2 is an exception to that, which applies the severity level 4 non-person felony as provided down there in lines 30 through 33. And then subsection B3 is also an exception to both of those rules. It applies the severity level 3 non-person felony as discussed there on lines 34 through 36, and then on to page 2. So essentially this just tries to restructure the penalty provision so that it's clear which conduct fits with which penalty, but it doesn't change the penalties that the bill as presented to you contained. It just changes the structure.
Thank you. Any questions for the reviser? Not seeing any. Is there any discussion or a motion? I will move that we amend House Bill 2583 with the structural change to penalties amendment that you have in front of you. Is there a second? Second from Senator Gossage. Any discussion? Not seeing any. Then you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. We are back on the bill. Is there any further discussion on the bill as amended? Yes, Senator Haley.
I know which way this is going, Madam Chair, but I should certainly share why I'm opposed and the distinct minority to this bill. We heard, of course, very learned testimony on both sides of the issue of especially not so much the service dogs, but the police dogs and their use, their ongoing, sometimes flagrant use. And just 3 quick sentences, Madam Chair, from written testimony that was provided. An organization called the National Police Accountability Project would respond by trying to defend themselves. According to one expert, a dog bite can flood the human body with adrenaline, making it difficult to focus on anything other than getting the dog to stop attacking, including listening to or complying with the officer's commands to stop, unquote. Second part, another part of that quote, in a number of recent high profile cases, law enforcement have instructed dogs to attack individuals who were on the ground, had their hands in the air, and were not resisting arrest or attempting to flee. Close quote. There's other testimony along that line. My ongoing concern with this bill is that it is a natural instinct if one is being pursued, whether one's innocent or not, or whether they're being set upon. These dogs often have even attacked their handlers. Police dogs have attacked their handlers, as testimony has been brought. And it's just an instinct to do whatever one can if you're being set upon by a dog. And then to have the restitution part put upon, the penalty, the fines and penalties put upon to replace the value of the dog when in self-defense. These injuries were incurred, to me is, I think it's a miscarriage of basic justice, especially prior to adjudication of any crime. So for those and other reasons, I know in the distinct minority, I'm in opposition to this bill. Thank you.
Thank you. Committee, further discussion. Senator Baumgardner.
Thank you, Madam Chair. As a point of clarification, the examples that the senator just shared, that is not testimony from Kansas, is it?
Senator Haley, do you want to respond?
Madam Chair, provided in our packet, this organization that did bring testimony is called the National Police Accountability Project. I don't know where they are based. However, they do draw from examples or concerns that are nation or nationally, and then they do refer specifically to one in one of the paragraphs on page 2 regarding Sedgwick County and Geary County, both in Kansas, where deputies were having problems with their dog. In fact, the trainers and handlers in both Sedgwick or Wichita and or Geary counties, of course, in Kansas were. So many of these examples may be from outside of Kansas, but this organization, the National Police Accountability Project, does cite some of our own from our state.
Thank you. Thank you, Madam Chair.
Thank you. Committee, further discussion. Not seeing any. Committee, we do have a motion and a second to move House Bill 2583 as amended favorably for passage. And we do have a second. So you all have heard the motion. Those in favor signify by saying aye. Aye. Those opposed, no. The motion carries. Yes, and Senator Haley would like his no vote recorded.
Thank you.
So noted. Committee, we will next work House Bill 2665, regards leaving the scene of an accident that has resulted in death to a person. And with that, then, a reminder from the reviser.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. As mentioned, House Bill 2665 does increase the penalties for a driver who leaves the scene of a vehicular accident in certain circumstances. I note that the bill keeps all the current penalties for leaving the scene with its various tiers of penalty based on the outcome of the accident that you left. The bill does increase the penalty when there's the death of any person and the driver knew or reasonably should have known that the accident resulted in injury or death. And that increases from current law severity level 5 person felony to a severity level 4 person felony. There's also a new provision that when the death of more than one person occurs and the driver knew or reasonably should have known that the accident resulted in injury or death, the penalty goes to a severity level 3 person felony.
Thank you. Committee discussion. Not seeing any, then is there a motion? Senator Baumgardner.
Thank you, Madam Chair. I make a motion that we pass out House Bill 2665 favorably for passage.
Thank you. Is there a second? Senator Haley. Any discussion?
I would simply say, Madam Chair, that we have had several situations exactly identified by this bill in Johnson County. We had a law enforcement patrolman that was killed by, it was an attempted hit and run. It was a hit. And then the individual tried to run but was captured. We had a very young boy where his father's vehicle, when he was a passenger, was hit. This happened just in Shawnee this fall. And the individual that hit them ran, and the little, I believe he was 7 years old, died from the injuries while father's was still hospitalized for some time. This is a very serious situation and deserves to be addressed in a serious manner. So I do hope that we get this passed into law. Thank you, Madam Chair.
Thank you. Senator Haley.
I concur with Senator Baumgardner. These incidents are unconscionable. They're beyond the pale. Where someone knows or should have known that an accident they're in is leaving someone in harm's way who could continue to linger or languish and even die. Um, Oftentimes that does happen. And I don't know if the penalty phase that we're moving to actually is strong enough. I think there should be a clear signal once this is passed, and I certainly hope it will, that is sent to the general public that there's certain ways that if you're driving a vehicle, the responsibilities that you have to yourself and to others on the road, especially in these incidents. So I hope we will unanimously concur, not only here at the committee, but also before the body as a whole, should this pass, Madam Chair.
Thank you. Any further discussion? Not seeing any, then you all have heard the motion. Those in favor signify by saying aye. Aye. Those opposed, no. The motion carries. We will next work House Bill 2675, and that's regarding non-parent visitation, and with a brief reminder from the reviser.
Thank you, Madam Chair. Jason Thompson, Revisor's Office again. This bill would enact the Uniform Non-Parent Visitation Act. It is brought to you by the Judicial Council, and rather than go into all the provisions, I would just say it replaces the current Kansas law on visitation for third parties with this uniform bill or uniform act that essentially allows someone to ask the court to grant visitation, but preserves a rebuttable presumption that the parent's decision was in the best interest of the child, and requires rebutting that presumption by clear and convincing evidence before it can be granted to let someone visit the child that the parent did not allow to visit the child. That's the main provision we talked about in the hearing that you might recall.
Thank you. Committee, any questions for the reviser? Senator Haley.
Is this the one, Mr. Thompson, that I had the amendment? This the one, or no? Oh, it wasn't this one. Okay. Thank you, Madam Chair.
Committee, questions for the reviser? Not seeing any. Any discussion? Any discussion, Senator Stephan?
Apparently so. And Jason might help me flesh this out. Would you be so kind as to explain the amendment for us, Jason?
Mr. Thompson.
Thank you, Madam Chair and Senators. Yes, so Senator Stephan raised an issue during the hearing with the Judicial Council representatives about how we would handle if, say, the sole bill passed and became law, and what would happen if those folks who have a custodian were then subject to this act, and how would this act interact with that act, and essentially how would this act interact with anyone who was in a custodial relationship. So with that in mind, the council went back and looked at the bill and had discussions with myself and the chair, among others, about how about whether the bill was clear about what happens with a parent or a person acting as a parent, which is how the act deals with these issues. And so they did not identify any conflict with the sole provision, if that does become law, or other provisions of Kansas law. But they suggested to make clear that the parent or the person acting as a parent gets the rebuttable presumption, gets all of the benefits of this law when deciding whether someone who's not a parent or acting as a parent gets visitation, that they needed to add that term or person acting as a parent in several places in the bill. So that's what this does. You'll see that same phrase added essentially anywhere the person, the parent is listed, the bill lists the person acting as a parent also. It was already done in a few places, but they missed some. And person acting as a parent is defined in the bill. That's a person other than a parent who has custody, who has been awarded legal custody, or who has, so it's physical custody for a certain period of time and legal custody. So essentially covers all the bases for who is serving as the parent. And that's what the amendment would attempt to fix.
Thank you. Questions for the revisor? Yes, Senator Corson.
Thank you, Metro. I think you said this. I just want to kind of get a yes or no, but the Judicial Council has seen this and they are approving of this language and this adoption.
Mr. Thompson.
Madam Chair, yes, I was directed to work with the council on this issue with the attorney and the representative who spoke on the committee's behalf, Mr. Nelson, and that was done. That I believe they are in favor of this.
Okay, thank you. I support this. Thank you.
Senator Gossage.
Madam Chair, the sole bill passed out of the Health Committee and it will be going to the floor. So I think this is very appropriate. Should that pass on the floor, this would be very helpful.
Sure, right. We don't know how it will advance or not, but that's good to have an update on the procedure. Discussion from the senator from Reno, Senator Stephan.
I'll certainly compliment all those involved in crafting this amendment. I think it's appropriate, effective, bridges the gap, and I move the amendment.
Thank you. Is there a second? Second from Senator Gossage. Any further discussion? Seeing none, then you all have heard the motion. Those in favor signify by saying aye. Those opposed, no. The motion carries. We're back on the bill as amended. Any further discussion? Not seeing any, then a motion. Is there a motion? Yes, Senator Baumgardner.
Thank you, Madam Chair. I move that we pass out House Bill 2675 as amended favorably for passage.
Thank you. Is there a second? Senator Gossage. All those in favor signify by saying aye. Those opposed, no. The motion carries. Committee, we are now going to move into our informational briefing on House Bill 2510, authorizing a party to obtain discovery of the existence and content of an agreement for third-party funding of litigation under the Code of Civil Procedure. And with that, some information from the revisor.
Thank you, Madam Chair, and good morning again, committee. I'll stand up here for the bill brief like normal. House Bill 2510, I'll just note, is not currently referred to the committee. That's part of the reason this is an informational briefing. It currently resides below the line in the House. It was requested in the Committee on Judiciary in the House by Mr. Stafford on behalf of the Kansas Chamber. It was heard and worked by the Judiciary Committee, then referred to appropriations to get it exempt for the session. And the committee passed it out favorably with some amendments after it was exempt and blessed, to use the term that's used around here. But it is currently residing below the line in the House. With that background, I'll give you a very brief outline of the provisions. I hope you have the bill as amended by House Committee in your packet. And I'll tell you that it does a couple of big picture things. It limits discovery and disclosure of third-party agreements in certain circumstances under our Code of Civil Procedure. And it requires reporting of those agreements to the Judicial Council and a Judicial Council committee to study those agreements and report back to the legislature. The bill's amending KSA 60-226, which is one of our statutes in the Rules of Civil Procedure about discovery. As introduced, you can see the language there on page 2 in lines 22 through 28. So as introduced, it was sort of a small provision about third-party agreements being subject to discovery, but as amended by the House Committee, it is a lot more new language. Essentially, the bill provides that you can obtain discovery of the existence and content of these third-party agreements, but certain ones that are defined in the bill are not subject to discovery in a normal way. You have to make certain findings, or you have to have certain protections for those agreements to have them disclosed. And essentially, the definition of third-party agreement is maybe a little narrower than it was at the beginning. It's these agreements, and you may recall this from testimony on prior bills on this issue, I hope. So I'm not going into as much detail as we have before. But this is essentially an agreement where an attorney representing the party has agreed to pay the expenses directly related to prosecuting the claim, and they have a contractual right to receive compensation that is contingent on the outcome of the claim. And there are some exceptions to that, and that is if the only thing you're receiving back is what you agreed to pay plus reasonable interest, which is defined in the bill as 11.1%. So if it's just that you're not getting any profit, you're just getting your money back, that's not a third-party agreement covered by the Act. So that's sort of a distinction that I don't know that was there before, but is much more clear. So that's one big change from what you might have seen before. The second change from what you've seen before is that certain third-party agreements are just not subject to discovery unless it's necessary to prove an element of the claim, and certain protections are imposed. And those are these agreements that might exist between the state and any political subdivision of the state and one of these third parties, or a case that's brought solely in the public interest on behalf of some group of the public. And those are all outlined in the bill in much more detail. So these public interest suits and governmental suits, if there is a third-party agreement, discovery of those agreements is more narrowly restricted and sometimes prohibited. The bill also, the other big part of the bill is requiring reporting of all of these agreements to the Judicial Council. So on and after July 1st of this year, if you have a third-party agreement, you're reporting that to the council within 45 days after the commencement of your action in Kansas court in which that agreement exists, or within 45 days after that agreement is entered to, whichever is later. So you have 45 days after the later of those dates to file a report with the council. The council then provides documentation that you did make the report, and the clerk of the Supreme Court is going to provide forms for that reporting. I note that those reports will be confidential, not subject to the Open Records Act, and that all of those provisions are going to expire July 1st of 2029. So there's a window here from 2024 to 2029 where this reporting will occur. And finally, the bill requires a Judicial Council committee to study these third-party agreements. On or before July 1st of 2027, the council is required to make a committee that's going to review all of those reports they receive and any other information they deem necessary. And then between September 1st of 2028 and December 1st of 2028, the council is to report to the Chief Justice, the Attorney General, both standing committees of Judiciary, and I guess that's all the reporting on this topic of third-party agreements, and make recommendations to you about what should be done about these agreements in Kansas. And those provisions would also expire on July 1st of 2029. So essentially, for the next 5 years, we'd have discovery provisions, we'd have reporting, we'd have a committee to study it, and then you'd be asked to come back and look at this in 2028, the 2029 session. And with that, I'll stop and stand for questions.
Thank you. Are the third-party agreements between the attorney representing a party and a third-party investor, or who is the third-party agreement between? Who are the parties to the third-party agreement?
Sure. Thank you, Madam Chair. So I'll just read you the definition because I attempted to do it earlier and I don't think I got it quite right. So I'll just read it. It's on page 9, beginning in line 23. It's any agreement under which any person other than a party, an attorney representing the party, the attorney's firm, or a member of the family or household of the party has agreed to pay expenses directly related to prosecuting a claim and has a contractual right to receive compensation that is contingent in any respect on the outcome of the claim. So it's essentially anyone other than the attorney involved, the family of the person, those sorts of people. So it's anyone outside of that group that has an agreement with.
Sure, but the agreement is with who? Is it with the attorney representing? This is usually plaintiff. Is it the attorney representing the plaintiff, or is it with the plaintiff, the client? Who is the agreement between?
That, and Madam Chair, that's an excellent question. I believe because it's any person who has this agreement with this expenses, that agreement could be with the attorney or it could be with the person, the client. I don't know that it specifies which one. And I think from the testimony we've heard, it's typically between a company and the attorneys, because the attorneys typically work on contingent fee basis in some of these cases. But I think it's possible under the definition that if you're a pro se, a pro se plaintiff, right, and for some reason you don't want to engage attorneys to bring your case, you could have a third party agreement to fund your case. And I think it's covered because any person, if they have the agreement, it's contingent on the outcome of your case, and they meet the definition, I think it's okay. So I think it could be with the client directly, but typically I think it's going to be between the attorney and someone else, or the law firm and someone else.
Okay, thank you.
Yeah.
Any other questions for the revisor? Not seeing any, then we have a couple of proponents and opponents as well, and running rather short on time, so we're going to limit conferee testimony to 3 minutes each, please. And first we will invite, and I'll run a timer, so when you hear the timer, please be respectful of it. And we will invite Eric Stafford with the Kansas Chamber and Ryan Kriegshauser also with Kriegshauser Nye Law Firm, or we'll have him second.
Yeah, Madam Chair,
Okay.
Thank you. Eric Stafford with the Kansas Chamber, and I'll have Ryan go shortly after me. So with the shortness of time, committee, good afternoon. Appreciate you guys taking time to hear this today, or good morning. In summary, I'll start by saying these amendments that are reflected in House Bill 2510, which was introduced as a similar version to take into consideration the changes from last year on Senate Bill 74. The amended language reflects agreement with the Attorney General's office that we negotiated. That's why the bill had to be blessed. It took about 3 weeks to go through different variations of language with them. Their main concern was the impact to nonprofit or public interest litigation, ensuring that donors or members of associations didn't need to be disclosed, or that parties wouldn't be disclosed. So the third-party agreements do not include. So we have commercial loans, and then we have consumer loans. You should have some written testimony by the consumer loan groups, which we did address in their language in the original House Bill 2510. They're still protected today for the more consumer loan. I need a loan in between paychecks while I'm waiting for an award or settlement, whatever, from litigation, if somebody was injured or unable to work, whatever that might be. But the amended language reflects largely all of the language was worked out with the Attorney General's office, who was officially neutral but had pretty strong concerns of on the impact of public interest litigation. In shortness of time, I want to point you to an article that came out yesterday in the Wall Street Journal. Says patent lawsuits are a national security threat. And it talks about this firm, VLSI Technology, that has sued Intel, microchip processor here in the United States. And then short of the story is VLSI, it's a non-existent defunct company since the 80s, 90s. And that they, through some digging, have found out that their parent company is called Fortress Investment Group, a hedge fund owned in large part by interests in Abu Dhabi. And there's concern that these groups are funding patent litigation. About 30% of patent litigation now in the United States is funded by third-party interests. And there's concern that these third-party interests, potentially by foreign adversaries, which is why you have the foreign definition in there, that was a big deal for the Attorney General's office, could be attempting to gain access to patent information. And that group that I mentioned from Abu Dhabi is a member of the International Legal Finance Association, ILFA, which is represented and will be opposed to this bill today. But that group is, when they were asked to, the judge in Delaware in the federal court said, yeah, we want third-party disclosure here. I'm going to award that. The group dropped their lawsuit against Intel. They did not want it to be disclosed who was backing and financing the case. And that is of concern when we're dealing with patent rights and patent issues. Another argument that will be made against this is that these are only for the small guys. And you're going to hear from a firm today that is opposed to this, that does these types of arrangements. Their website says they take claims that are more than $10 million. So we're not talking small money here. These are big money lawsuits. It's not about protecting the little guy as what is being used against this legislation. And then I'll close, Madam Chair, by saying that Indiana and Wisconsin, within the last 2 weeks, have sent bills to their governor. Indiana had a combined 2 votes against the bill. Not Wisconsin, West Virginia, I'm sorry. West Virginia passed on final action in their House. I believe the vote's in my written testimony. I think it was 87-11. So what has turned into a controversial multi-year effort here in the state of Kansas appears to be flying through other states without really much objection. There are trial lawyers and trial bars in those states too, and there is strong bipartisan support for this type of disclosure out of fairness for the judiciary. If we're going to turn the judiciary into the stock market where we can profit off of litigation, we ask that that be disclosed so both sides, just like on the insurance side, can have a fair determination on whether settlement is the right option or whether to go to trial. So it is a disclosure piece. That is what we're asking for. There is the sunset, which we're not crazy about, but we're willing to do it so that Judicial Council can report back to you guys to see how big of an issue this is here in the state. So I'll close and save the rest of my time for Mr. Kriegshauser and be happy to answer any questions at the end.
Thank you. Well, the buzzer went off, so there's no more time to cede over to the next proponent, but thank you for your testimony. And next we will hear from proponent conferee Ryan Kriegshauser with Kriegshauser Nye Law Group. So please introduce yourself and welcome.
Ryan Kriegshauser, partner Kriegshauser Nye Law Group. Glad to be here. I'll keep my comments very brief and stand for questions. Our law firm has worked with the Kansas Chamber on a number of legal issues throughout the year. And really what I want to bring forward is this idea of moral hazard. When you have a third party and you take the focus away on litigation from a client and you are focused on profit, or you're focused on access to national security information like you just heard from Eric Stafford, that changes the whole complexion of litigation. You're no longer interested in what the client needs. You're interested in what the lawyers, they're going to get a ton of money, and the investors, they want a ton of money, and profit or access to national security information becomes the focus of litigation. And this really comes to the business aspect of law, which a lot of people don't really understand. But we saw this with ADA litigation last year, that Kansas was the first state in the nation to actually fix it. And I had a plaintiff's attorney who was very prolific in ADA litigation tell me, I'm never coming back to Kansas because of the legislation that this state passed. And the reason ADA is so successful is because it has an attorney's fee shifting provision. And all of a sudden, lawyers can hold small businesses captive and say, if you don't just pay me a nuisance settlement, you may have to pay me to litigate this case, and it's going to cost you hundreds of thousands of dollars. Well, this also impacts the business aspect of law because you have funders dumping in, and I don't think Eric mentioned it in his oral testimony, but it's in the written testimony, the Cisco lawsuit against its suppliers and basically an antitrust action. What their capital funder actually tried to prevent a settlement. Cisco was like, we want to settle. These are our suppliers. We've reached a settlement. And their funders were like, it's not enough money. You're going to keep going. And they actually sued Cisco to make them continue the litigation. So you have this perverse incentive for funders to step in and demand more money. And I just want to mention a few more things. Like Eric said, insurance, this is the other side. This is a plaintiff side, the financing side. It determines the value of the case. You'll hear people say, this is already admissible. A judge could do this today. Well, that's not necessarily true. It doesn't necessarily relate to an element of the claim, just like insurance doesn't necessarily relate to an element of the claim. It determines the value of the case, though. It's incredibly relevant to the entire action because of the business aspect. How much are you willing to pay to fund this litigation? How much is that insurance policy? How much is my claim worth? They're two sides of the same coin. And so I think that's important to mention, because the rules of disclosure and discovery don't necessarily make it admissible without this type of litigation. And just real quick, I want to say, we've done public interest litigation and we've used third-party financing, but we're very careful about that moral hazard I've talked about. We saw this a lot during COVID. One example here in Shawnee County, where the health officer issued these PDFs that were pre-signed, and any teacher could fill them out and quarantine students for 2 weeks. A parent brought a lawsuit here in Shawnee County. It worked its way through the Court of Appeals, and there is a scathing Court of Appeals opinion saying this case is moot because no reasonable person would think this practice was legal. And we had a clear precedent saying, absolutely not, Shawnee County. No one should ever do this again. And that's what the client wanted. Imagine if there was a third-party funder saying, we want false imprisonment claims for all these parents. You'd have a massive class action. Shawnee County would be on the hook for who knows how much money. The funder is demanding as much profit as possible. The parents are like, we want to be done with this. COVID's done. We got a good Court of Appeals opinion. The public policy is set. And they just want to be done with it. And it would cause that lawsuit to go forever. There's some class action settlement. The parents get a pittance. The lawyers walk away with the money. And so did the investors. And so I just want to use that as a possible example. Stand by for questions, and I appreciate the time.
Thank you. Are there any other conferees wishing to provide proponent information? Not seeing any, then want to direct committee's attention. We do have proponent information from Mike O'Neill, Alliance for Responsible Consumers, and I do have a couple of questions for Mr. Kriegshauser. If you could come to the podium and
Thank you, Ryan Kriegshauser, Kriegshauser NILAW Group.
Thank you. I went ahead and looked at some of the opponent information that you were talking about, and you've touched on it briefly, that sometimes the point is made that unlike insurance agreements, these third-party funding agreements would not be relevant to the underlying merits of the case. And I think you said that insurance agreements and third-party funding agreements are both sides of the same coin, because they both generally don't go to the merits of the underlying claim, but to the value of the claim. And could you just touch on that briefly, because we have kind of opposing information?
Sure. Just as a lawyer in the business side of law, you can have a perfectly great claim against a party that is judgment proof. That's what we call it. They have no money. So you can sue them and you can litigate it all day long. You're just going to spend time litigating. But at the end of the day, there's no pot of gold at the end of the rainbow, so to say. They just have no money. But what they may have is an insurance policy. And then the game changes. What are the policy limits? Because that's the value of the claim.
And you know what the policy limits are, because not you, but a plaintiff would, because the defendant who has the insurance has to disclose the insurance agreement, which would include the policy payment limits.
Absolutely. That's a very important part of discovery. The plaintiff wants to make sure that there's a policy there and know what those limits are. And so this is the opposite side. So the defendant is sitting there wondering, how much money does this plaintiff have to throw against this lawsuit? If it's a mom and pop shop, they may have, there are consumer finance litigation firms, and they pay a set amount with interest. But those plaintiffs are probably going to pay that back. It's not based on contingency oftentimes. It's based on any loan where you would pay it back with interest. This is different. And a defendant would want to know if there is a big, a big capital firm sitting there saying, we're willing to throw $100 million into this lawsuit. Well, then the calculation changes because you're going to spend a ton of money litigating this case. So you want to settle for the lowest amount possible. So that's why I say it's two sides of the same coin.
So historically, because I remember from last year some testimony that the group that's supporting the third party financing, I think that group had come into existence about September of 2021, so pretty recently. And if this is a relatively new practice, the third party agreements to finance, how is it working before? Because we've always had, David versus Goliath type lawsuits, and they've been proceeding just fine. Who was bearing the risk without the third party financing agreements before this kind of industry came into existence?
Yeah, I think this is a fairly recent development, just like ADA litigation. The practice of law has profit elements that are being discovered by creative folks. But prior to that, there are ways the market works this out. You have lawyers all the time willing to finance litigation. They're called contingency fee lawyers, basically. And we take very few contingency fee cases. We have taken some, but that's a decision. Me and my partner sit down. How good is this claim? Are we willing to pay and invest our time and our resources as a firm? The client doesn't pay a thing. And if we win, then we take a bigger chunk of that ultimate settlement. And so that's one way, is contingency fee cases. The other way are those those consumer financing firms that exist already. But again, this is different. It's more a contingency investment idea by a third party rather than here's a loan for your expenses while this litigation is going on, or to fund the litigation, but you don't have that same moral hazard because it's based on interest. Like, it's a set amount and I get a set amount of interest, not if you win, I take a third or 50%, if that makes sense. So the market has kind of worked it out in many ways.
Do you have any position on, we heard from one of the opponents in written testimony that the disclosure that the bill is proposing would put the plaintiff at a strategic disadvantage and gives the defendant and their insurer information about plaintiff's financial position and willingness to settle? To me, that looks like it's about willingness to settle and not the merits of the case. But just wondering what your position was as I'm reading that.
I'm just, in practice, it seems like it levels the playing field rather than puts them at a strategic advantage. It's that coin that I'm talking about. You can find out the insurance amount to see the value of the claim. This would show the defendant, like, okay, well, this is how much they're willing to invest to litigate the claim. So I don't think it's an advantage. It's more equal.
Thank you, committee. I've asked a lot of questions. Are there other questions for the proponents? Senator Corson.
Thank you, Madam Chair. So this is the third year that we've seen this bill or some version of this bill, and I've struggled with this from the beginning because it seems to me like this is really kind of a solution in search of a problem. I mean, put simply, I've been asking now for 3 years for evidence about the number and volume of third-party finance cases that are happening in Kansas courts, and I've never gotten that information. I would love if you have that here today. But, the case that Mr. Stafford mentioned, the federal that case involving Abu Dhabi, that's a federal patent litigation in the United States District Court in the District of Delaware. It's not a state case. The Cisco case that you mentioned, those are federal court cases in California and Texas. Again, they're not state cases. So my point is that litigation financing is really happening in these antitrust cases, these patent cases, these big class action, these big MDL cases, which are overwhelmingly in federal courts. So anything that we pass, whether we pass this or not, would have no impact on those sorts of cases, because any law we pass would only impact, obviously, our Kansas state courts. And so I'm, again, kind of searching for evidence or information that this is a problem that needs to be solved for our Kansas courts. Can you help me with that?
Yeah, I think I don't have information statewide. I think this bill would help us get that information because the Judicial Council would study it and we would be made aware of these. I can tell you, like I said, we've been involved in public interest litigation against government entities in state court. And our firm has been approached, I think, 3 times for capital investment by third parties. So I know it happens. I can't tell you how much it happens, but it's happened to us. But it's been suggested that maybe we could partner on financing. But we've always had the funding necessary for us to bring our claims, because we structure it the way we want to, which is basically funder. You give us the money, it sits in a public interest litigation fund for the purpose of the public policy interest that you gave it to us for. You're not getting any of this money back. You're not getting interest on it. If we get attorney's fees, it goes back into that fund and we'll litigate another case. But there is no profit motive by any of our funders ever, that they're going to profit off our litigation. We do that specifically because we want to avoid the moral hazard of having a funder push us to say, you know, I know you want to settle, but it's just not enough money for our funders. And we want to do the next big case with them too. So we want to keep them happy.
I mean, I appreciate that. I appreciate the information about your firm's specific business model, but it sounds like you don't really have any specific information to bring to the committee about the prevalence of this statewide,
No.
because again, this is really a federal issue in these large kinds of cases I mentioned, antitrust, patent, big MDL, big class actions. This is really not something that's happening in Kansas state courts.
No, I think we'd get the information through the bill, through that report.
Thank you. Committee, other questions? I have one final question. We do have a proponent written only, and that's regarding paying your bills as a consumer while you are litigating a case. And I mean paying your bills like for food and housing and things like that. Was that group, I'm trying to find the name of it. Yes, Alliance for Responsible Consumer Legal Funding. Last time we had this policy in front of us, were they an opponent and they have now moved to support, or do you have any information about that?
Yeah, I've worked with the chamber on this issue for a few years, and I think they were at first an opponent. And so because of our interest in public interest litigation, we watched this bill and worked with the chamber very closely to try and make sure public interest litigation could move forward. But we also had numerous discussions with that group to make sure that their funding model, which takes into account that possibility of moral hazard, you know, and the rules of professional responsibility in Kansas also is very sensitive to the idea that there's an outside interest and the client isn't the main focus of the litigation. So yeah, we made changes to accommodate them.
Finally, this might be a question for Mr. Stafford, but I think you can probably answer it. Other states, have something in place like this?
Yeah, I know of 2, but I'll let Mr. Stafford, he probably has been tracking this more nationwide.
Yeah, I just want a quick answer that,
I believe there were 2 in the testimony that we cited, but I'll defer.
okay, Mr. Stafford.
Yeah, Madam Chair and members of the committee, Wisconsin was the first to act this, I believe, and enact this in 2018. The most recent, I mentioned Indiana and West Virginia just within the last 2 weeks. But other states are now starting to look at it. But it is such a new issue that at the state level, there just hasn't been a lot of action yet, but you're starting to see more and more states. I think I can't remember the exact number from the most recent newsletter I read, but 10 states, maybe 12 states are starting to introduce this and look at it. But there's some written information in our testimony that right now, even at the federal level, to Senator Corson's questions, it's kind of, there's some judges that do require, and some districts that do require disclosure. It's just not quite uniform yet, but there is a growing effort, especially in Washington, D.C., to make it required.
Thank you. Are there any conferees wishing to testify as neutral? We're going to move on, but any conferees wishing, I'm sorry, we then will move on, not seeing any, on to our opponent conferees and invite Mr. Daiwai Chin Phenom from Parabellum Capital to the podium. Sure, we'll reverse the order then. John Federico with Federico Durst Consulting Group. Please introduce yourself and welcome to committee.
John Federico Durst Consulting here on behalf of ILFA. I appreciate the accommodation. He did fly all the way in from the East Coast. If there is any opportunity, I'll yield as much time as I can to him, but something more than 3 minutes. Again, thank you for the opportunity. I echo much of what you're going to hear is are points that I have made for the last 2 years. What is the problem we're trying to fix in Kansas? Has a single example been raised that would necessitate this committee, this legislature, to supplant the oversight, expertise, and judgment of our judges? Because there already is a system in place by which you can petition the judge to force disclosure if it is relevant to the case. Now, what we've done with this legislation is replace relevance to the case with some language that the committee, I'm not quite sure with where this came from, but if you look on page 2, lines 33, as they consider forced disclosure, when making such finding, the court shall consider the political, ideological, or social nature of the case. And this one I really don't understand, that you're going to put in state statute, the likely balance of litigation resources between the parties of concern to us. Again, when did the legislature start singling out a single company, albeit it's a new emerging company of litigation financing, a critical resource in almost every circumstance? But when did we start inserting ourselves into the business of presenting, requiring contractual agreements between private parties? It's a slippery slope that has us concerned. The other point is the convoluted and confusing reporting scheme to the Judicial Council. On page 3, Madam Chair, when I look at lines 31, it does not wait for the judge to rule as to whether it needs to be disclosed. Automatically, once the suit is filed and or a contract is signed between these two private parties, within 45 days, they have to report it to the court. More or less, that's forced disclosure. So I'm not quite sure what the rest of the bill will accomplish. I say that respectfully. And I'll close with this. I ask you to look at this bill and tell me what part of this bill helps the little guy, the small business that has limited resources, so that they get not only access, but full access. They might be able to afford the original lawsuit, but of course, anyone who has the resources will appeal. And that's the problem. That's when, in certain circumstances, companies like this exist. And again, I'm not used to an informational hearing. I don't know how to close, but thank you for considering these facts. And I yield my time. One last thing. We mentioned a lot of states rejecting this are plenty of conservative states: Florida, Texas, Missouri, Ohio, Nevada, Utah, Oklahoma, Georgia, and North Carolina. So thank you, Madam Chair.
Thank you. And I clearly need a bigger alarm, a louder alarm on my phone, because there's no time remaining to see. But thank you for your testimony. And next we will hear from Daiwei Chin Feeman, Parabellum Capital. Please introduce yourself and welcome to committee.
Thank you very much. My name is Daiwei Chin Feeman. I'm a managing director at Parabellum Capital, which is a member of the International Legal Finance Association. I came here from Boston, where I was celebrating my father's 81st birthday. I'm glad to be back in Kansas for the first time since a wedding in McPherson in 2007, where I grew to love beef ribs. Let me tell you a little bit about who I am and why I'm here. I am the only person I think that you've heard from over the past years who actually knows a thing about this industry. I've been in it for 6 years. Before that, I was a litigation partner at a large national firm, Dorsey & Whitney. I got into this for access to justice reasons, and that's what we do, and I love it. We provide capital in David versus Goliath disputes, and let me just tell you, David versus Goliath disputes, the Davids can need millions of dollars in legal fees because the Goliaths have insurance companies willing to spend it. And this can be a small, closely held family dispute. It can be someone who gets cut out of a will. There's plenty of instances where the little guy needs millions of dollars, and that's what we do. We invest over $5 million in our average case, and these are real, serious, meritorious disputes. We only invest in meritorious disputes because we have investors that we report to, and we have a duty to make money for them. People approach us for capital. We're there because there's a need for us. And when we provide that capital, it helps level the playing field and provide access to justice. I'm very concerned by a lot of what I've heard here, especially by the proponents. Just in case you didn't know, this bill is part of a coordinated national campaign by the Chamber of Commerce, which started in 2014 for obvious reasons. Historically, the way it worked, and I submit respectfully that David versus Goliath disputes weren't going along fine before. Many were never brought, and when they were brought, they were under-resourced. There's a very small market for contingency lawyers, and so we actually enable meritorious claims to be brought in to hold bad actors accountable for what they do. We are passive. We're not like insurance companies. This is not the same side of this, a different side of the same coin. We do not control litigations. Insurance companies can control. We can't do that. There's no moral hazard. We have no rights. It's the litigants actually who hold us hostage. They say you're passive. There's a protective order. You don't even know what's going on in the case. We're going to settle it. We're either going to settle it where you get almost no money, or we're going to drop the case. We're at the mercy of the litigants here, not the other way around, because we're passive. I can systematically debunk everything that the proponent said. A lot of it's already been debunked, such as the federal nature of many of the disputes. The Burford versus Cisco story I've written extensively on, and I can tell you the truth of what happened there and how it's not a concern. But what I really want to do is talk about how this is a positive for access to justice. And I think the bill implicitly recognizes that. This is something that we're going to allow to happen in Kansas, and we want to be legal. But in doing so, let's not put a bill forward that prejudices the parties who need the funding to begin with. This automatic disclosure, which would automatically allow the defendant to get access to things like the litigation budget for the case and the strategy, which is set forth in the litigation funding agreement, that's a roadmap for the defendants to crush the little guy. Mr. I believe Krunkhauser, who testified before me, said that that's exactly what he wants. He wants to know exactly how much money the plaintiffs have so the defense can outspend them. National security is another area where I'm very concerned. I do not want to tell you that I'm not worried about China interfering in our country. I'm all for it, but we have nothing to hide as a litigation funding industry. But I encourage you, this is an informational session. Please ask me any questions you have. I sit on the front lines of this. I've been doing it for years. I've been involved in all the public policy aspects of this, from the Federal Civil Rules Advisory Committee to testifying in multiple states, to being a chief author of the New York City Bar Association's study on litigation funding, a member of its professional ethics committee, the Uniform Law Commission study on it, as well as other things. I know this stuff inside and out. I live and breathe these issues, and I want to provide access to justice. It's just bills like this make my job very hard, because what you're witnessing is someone trying to pass a bill in a state that doesn't really have a lot of skin in the game. If we're looking at how much the solution in search of a problem, that's the reason the bill is brought here. This state is being used to gain momentum in other states, which are not major litigation hotbeds, to develop momentum for the chamber so that it can attack our industry nationally, because we help the little guy. So what I would encourage you to do as you look at this bill is, as my colleague said, is it really necessary? We have policies and procedures in place for this. If you want to do a study to find out if there's a problem, do the study. But let's not get ahead of ourselves and have provisions in here that will create additional new problems. We have here an automatic disclosure provision, which then allows on motion a funded party to contest it based on multiple factors. That's inviting an automatic motion in every case where there's funding, which adds to, which hurts judicial economy. On top of that, the foreign disclosure requirement is nonsensical. You were going to do a study about foreign countries and their involvement in litigation. Well, how about we limit that to countries of concern? The two of the biggest litigation.
We are at our 3 minutes and plus, so just want to have an opportunity for questions.
May I just finish that point, because I think it's important?
Sure, finish that one last thought.
The study here of foreign involvement in litigation encapsulates all foreign countries. Two of the largest litigation funders are technically foreign, Burford Capital and Omni Bridgeway. Most litigation funders active in the United States actually are headquartered in the UK or Australia. So you're actually looping in plenty of entities that I don't think are really the cause for concern. Other states, such as Indiana, that you've heard, they've restricted the disclosure to countries of concern, such as Iran, China, Venezuela under a certain regime, et cetera. Thank you.
Thank you. Appreciate it. And committee, we do have opponent written only information from Gary Barnett, International Legal Finance Association, Callie Denton, Kansas Trial Lawyers Association, and Joseph Molina, Kansas Bar Association. Are there any questions before I open it? Are there any other conferees wishing to present opponent information? Not seeing any, then we'll go ahead and open it up for some questions. Senator Baumgardner, I saw your hand.
Yes, thank you very much. Thank you for your testimony. Would you address, please, something that was mentioned by the Mr. Federico before you, but that was with regard to when making such finding, the court shall consider the political, ideological, or social nature of the course, the likely balance of litigation resources. Talk to us about how that would impact or perhaps harm the little guy that we keep referring to.
What happens when litigation funding is disclosed in a case is once the defendant finds out their funding, they're like a rabid dog. They then serve subpoenas on the litigation funder. They request all the communications between the funder and the funded party, where we have to ask them about strengths and weaknesses in their case, and it's very candid. We get subpoenas that have 50 requests long. It turns into a fishing expedition that creates more and more satellite litigation. So to avoid that, every time there's funding, the funded party here, this bill invites them and will have them make a motion which says we have less resources or otherwise. I think this needs to be amended to have an ability to argue that there's not going to be prejudice to the case. Again, we don't want to have funding which helps the little guy and then hurt the little guy through a backdoor trap in the bill. So the resources of the parties are very important because this is about the defendants outspending the plaintiffs. And if they have access to the litigation budget, they know how they're going to be able to outspend us. We don't devote unlimited money to every case. We have a certain amount of money that we can invest, and we allocate it among cases. And there's a certain budget for each case, and if the defense knows it, that's absolutely prejudicial to the case. Same thing if they know our return structure or other strategic elements which might set forth in litigation funding agreement about certain work product that's contained there. And many courts have held that the information is privileged and work product. And I will point out that there's an ambiguity in the statute about privilege, which I can address.
If I might follow up, Madam Chair. I guess I'm really wanting to know a little bit more about what are other times in which the court considers political, ideological, or social natures of a case, and I would like Mr. Federico to address on page 4, item D, with regard to the Judicial Council. But if you could address
I don't have a very useful answer for social, political, ideological, because that's not our business. We're invested in commercial litigations that are there to make money from meritorious claims. That's what we do. We're not bringing claims for political, sociological, social, or ideological reasons. Maybe there are public interest groups that do that, and it looks like you guys have got a nice little exemption for them in this bill. For us, we're in this just like contingency lawyers are. They are our main competition, in fact.
Thank you. And if I might, Madam Chair.
One last question, Senator.
Yes, my question is in section D, so starting in line 11 through 21. So with this bill, this would be for Mr. Federico. So do we have the cart before the horse with this bill? Is this not something that the Judicial Council should establish a committee to study on prior to enacting this law?
That's an excellent point, one we've tried to make.
Please go ahead and introduce yourself.
I'm sorry, John Federico, Durst Consulting. Yes, Senator, I agree. There's a lot. There are many parts to this bill that, to us, seem contradictory and unworkable.
Just to clarify, our industry does not have anything to hide. Excuse me, Dywitch and Feeman Parabellum Capital. We have nothing to hide. We're completely open to a study. What we don't want is just to prejudice the cases that we're funding. We don't want to hurt the underlying litigants because they came to us to ask for money. What I apologize for butchering his name, Kriegshauser said shows that the intent of the bill is to prejudice the plaintiffs. That would defeat the whole purpose of access to justice, respectfully.
Thank you. Senator Wilborn.
Thank you, and thank you for being here. I was going to ask you a question as it relates to a standard operating procedure. Obviously, you have a select committee or an underwriter, so to speak, that evaluates these cases based upon the fact set. There obviously are some cases that you will decline because it doesn't. So you kind of measure them and weight them. Is that how you select them?
Yes, and I would say we decline well over 90% of the inquiries that we receive. We have an intense, thorough underwriting process involving former lawyers such as myself, as well as the use of outside counsel. We also conduct background checks on our counterparties to make sure we can trust the people that we're in business with, because again, we are passive. There's no moral hazard here. There are protective orders in litigation guarding confidential proprietary information. We don't sign those. We don't even know what's going on in most of the litigation we fund after it's funded because, again, unlike insurance companies, we are passive.
Thank you. Senator Corson.
Thank you, Madam Chair. I want to first pick up on something Senator Baumgartner raised. I mean, I view this as kind of essentially a big government bill. I mean, I can't think of hardly any other times outside of very exceptional circumstances that the state legislature would pass a law that would say two private parties contracting would have to then turn over to a government entity, the Judicial Council, the contents of that private contract between two private parties that they've willingly entered into that's an arm's length transaction. I just find that very problematic, and I'm glad Senator Baumgartner raised it. My question is, can you talk a little bit more about what you've raised about the difference between how, because what we hear from the proponents is this is just like insurance agreements, is just like disclosure of insurance agreements. My view is that's different. Insurance is risk shifting. Those insurance companies are active. They take over the case. They have their lawyers who are running the day-to-day operations of that case, of the defense. This, what you're doing, my understanding, is passive investment. So it's very much apples and oranges. And I think the proponents continue to try to conflate that and say it's just like insurance when it's completely different. It's passive investment versus the insurance companies who are running these cases.
Yeah, insurance is very different in a lot of ways. And I'll tell you, if we had the same rights to control litigation and the same access to information that insurers did, there would be much less of an issue. But the thing is, we're passive. We don't have that. And that's why part of why we need these protections. Insurance is for a totally different reason. We want to make sure that claims that shouldn't be brought, that are just going to be Pyrrhic victories, don't get brought. The idea of this bill is the opposite, as Mr. Krieghosen said. He said that they want to know how much money plaintiffs have so they can outspend them so that the litigation that was meritorious can cease. That is the opposite of trying to encourage meritorious litigation. I will say there's an intermediate approach that could be considered. If we identify here the problems, it's a solution in search of a problem. I will say there's certain low-hanging fruit that could be addressed. If you're worried about, say, conflicts of interest between judges that could be invested in a litigation funder, you could require that parties and their lawyers certify that, they can tell the judge in camera who the funder is and they can certify there's no conflict. If you're worried about litigation funders having control and not truly being passive, the court can review in camera the clause of the contract which says it doesn't control, and there can be a certification signed by the funder, the party, the lawyer that says there's no control. And this is what Judge Polster did in the opioids MDL. He required declarations from each funder and each attorney saying that there's no control. That eliminates a lot of the problems. So you could do this by certification. You have attorneys who are members of the bar who would submit to this. They can certify no conflicts, no control, no access to information under protective orders, and no foreign funding from countries of concern. This can all be handled without production of the funding agreement, which will give Mr. Krieghosen the information he needs to prejudice the claims that we've been trying to help.
Thank you, committee. We are way over time for our committee meeting, and we do have one more informational briefing to get to. So I'm going to then close the informational briefing on House Bill 2510 and thank our conferees for coming today and presenting some information. Appreciate that.
Thank you for indulging.
So yes, thank you. Safe travels, everybody, back to home. So, and finally then a brief informational briefing on Senate Bill 503, increasing the criminal penalties for knowingly and maliciously abandoning any animal in any place without making provisions for the proper care of the animal. So just a brief would be great. Thank you.
You got it, Madam Chair. Jason Thompson, Revisor's Office, shortest one of the year. So this is a bill that increases the penalties for knowingly and maliciously abandoning any animal in any place without making provisions for the proper care of the animal. Current law covers knowingly doing that. This adds maliciously and increases the penalty when it's done maliciously. That's all.
Thank you, committee. Any questions for the revisor? Senator Haley.
Mr. Thompson, does this augment greatly Scruffy's law? Creating the felony for extreme cruelty in animals?
Madam Chair and Senator, I believe this is the statute that was amended back in 2006 or so that you are very familiar with. And this does increase the penalties if the malicious element is there. So it would be an additional penalty to what you've already enacted.
Additional? It would not water it down?
No, it would be an additional penalty for additional malicious conduct.
Thank you, sir. Thank you, Madam Chair.
Thank you. Any other questions? Not seeing any, then We have a information from proponent, Miss Christy Fisher. And there's a couple of you, but I don't know if it's the same testimony, we don't allow, excuse me, if it's the same information, we don't allow repetitive presentations. So if it can be said by one, that would be great, especially since we are far over our time. And if we can limit that to 3 minutes, that would be helpful. There is some information in committee folders that has been provided, I think, by the Wichita Animal Action League. And so with that, then please introduce yourself and welcome to committee.
Thank you very much. I almost said good morning, but it's good afternoon now. Thank you, Madam Chair and the committee. I'll try to keep this as brief as I possibly can. My name is Christy Fisher. I'm the Executive Director of the Wichita Animal Action League, or WAL. As a side note, just because it pertains to this, I am also a former law enforcement officer in Sedgwick County for nearly 10 years. And I'm a nationally certified animal cruelty investigator, as well as an instructor for the National Animal Cruelty Investigator School out of the University of Missouri. So the reason why we are attempting to pass this bill through is because in 2020, there was a situation that involved a dog named Bowie. And in a nutshell, Bowie's owner made the decision to place him in a kennel. He was nearly starved to death at that point, and the temperatures were below zero. And he was intentionally carried outside and placed next to a commercial trash dumpster in an apartment complex. He absolutely would have died, which was supported by veterinary statements later on, if he had not been found simply by coincidence. Unfortunately, however, this defendant was charged with a misdemeanor because under the current animal cruelty statute, our Sedgwick County District Attorney did not feel that they could charge with a felony. Because of that, we are pushing forward to try to get additional changes made, as noted for Senate Bill 503. What this would essentially do is allow additional conduct to be considered a felony by adding a substate or subsection prohibiting maliciously abandoning any animal in any place without making provisions for its proper care, and defining a violation of that statute as a non-person felony. We feel like this is very much necessary, and after speaking to multiple prosecutors, they also, in many cases, agree with us, because currently the behaviors of caging a dog without food and water in the county, where it's going to slowly die of starvation and dehydration, and caging a dog without food and water and throwing that cage into a dumpster so that it could be crushed by a trash compactor at pickup, it's just as malicious and blameworthy as killing, injuring, maiming, torturing, burning, or mutilating any animal, which would fall under subsection A, allowing it to be a felony. Unfortunately, issues like this, which are not uncommon in our state, are currently being charged as misdemeanors. We believe that this statute should absolutely be changed for a number of reasons, but as a former law enforcement officer, as a national animal cruelty investigator, I can absolutely tell you that there have been study after study that show that there is absolutely a link that exists between human violence and animal violence. Animal cruelty is a predictor of current and future violence, including a multitude of violent crimes such as assault, rape, murder, arson, and domestic violence. Because of this, the public, which we saw at length during 2022 when Bowie's case was running strong, is advocating for stronger penalties for malicious cases of animal cruelty. I'm sure I'm about out of time, but I further would like to say that this amendment is not going to impact ranching, farming, or efforts to control pests or predatory animals. Finally, we just ask that the committee potentially consider passing this through, as we feel like this is a matter not only of making a moral change that is needed to the law to update it, but also it's a matter of public safety due to that established link between human and animal violence.
Thank you. Appreciate your information here today, and the printed out information you provided has been distributed to the committee. And because of some potential legal concerns raised by our Kansas Revisers and Research Department, we want to make sure that we're not violating any copyright issues if we were to share, because some of the information is newspaper articles. But if the public wants some of the information or all of the information that we've distributed, they are free to reach out to the Kansas Legislative Research Department. That can be found on the Kansas Legislature website. So, yes. And with that, then, any questions? Yes. Senator Haley.
Thank you, Madam Chair. I'll be brief. And thank you for being here in your testimony today for this informational hearing. Full disclosure, I lobbied for 7 years the legislature to create what is known as Scruffy's Law, which created a felony for extreme cruelty and neglect to animals. It was my law. It was my signature piece for a long time, and I continue to be proud of it. I'm concerned about this particular measure before us by way of a particular case example that you might give. People do abandon their animals, and I'm concerned with the increase of the penalty, underlying penalty, for those people that drive their dogs out to the outlying areas and simply release them into the wild. Would that be an extreme example of this, or would that be something that would be covered if people were simply to let their domestic animals, their pets, loose in some area? Would that then be applied?
Yes, sir. So I would consider that to be an extreme example. What we're commonly seeing and what we have seen in our jurisdiction is more along the lines of people that are moving out, not letting anyone know that there are pets, intentionally leaving their animals, most of the time kenneled or caged inside the home, where there's no provisions being made. No one is asked to come check on the animals. Animal control isn't notified, and the animals are slowly just starving or dehydrating to death.
Well, thank you. I actually had rental property and actually went into the basement and found 2 dehydrated, dead puppies in one of my houses, rental houses, and tried very much to find the my former renter, and for that very reason. So I'm concerned about that, but I would not want to see it applied to those who have no other recourse, who can't put their animal down or have their animal euthanized, or who abandon them at least into the wild, and have that applied there. I mean, because that happens more times than I'd like to see, but it's a reality.
It does, but I will respectfully say, sir, that there are absolutely other recourses. That is the whole reason the Wichita Animal Action League exists. There are absolutely recourses for people abandoning them, especially way out in the county, to pretty much a certain death is not appropriate. And we find that most of the time people just haven't taken the time to do a simple Google search to find what resources exist in their communities.
Okay, thank you.
And thank you. And a brief question from Senator Gossage.
I know we're way over our time. I share some of the same concerns. By the way, I've lived in the country for 42 years, have 4 children. So lots of animals would just show up at my door, and we always took them in and gave them food, but they just stayed outside. So in your testimony, you mentioned prohibiting abandoning without making proper provisions, but you do indicate not provide food, water, protection. So I have some of the same concerns that Senator Haley was missing. Who determines that they were left out? Was there enough food or water? Like, you leave them in the country, but did you give them food? Did you give them water? And that I could see where there could be some folks that pretty high, what's the word I want? Representative Haley or Senator Haley, but the way that they would be taken to court, or the fine that they would have to pay. I'm all for, let's not be cruel to animals. Obviously, we took in a lot of animals, but I think to have this be more clear in the bill as to what is that, what you state here is obviously more clear, but just saying that they were not given provisions, I don't think is clear enough.
I appreciate that, ma'am. To be fair, I believe that the term maliciously here is very, very important in how this would be applied by potentially prosecutors. Also, this is just giving prosecutors a little bit more discretion to be able to decide when a misdemeanor charge versus a felony charge would be most appropriate based on the circumstances at hand.
And I would just say defining abandonment without proper provisions may be easier to clarify that within the bill.
Yes,
Thank you
ma'am.
very much. Thank you, Madam Chair.
So maybe some things to consider after the informational briefing about the bill and what that could look like. So thank you very much for being here today and for waiting for so long for us to get at the end of our committee meeting today to your issue. So thank you for bringing this forward. Appreciate it.
Thank you, Madam Chair.
With that then, committee, we will close the informational. Well, I want to ask, are there any other persons who wish to offer proponent information on the bill? So not seeing any. So thank you. We will close the informational briefing and we are far past our time today. However, I do think there is a bill that we have been waiting for amendments on that are ready. And since we still do have a quorum for a minute, we will go ahead and take a brief look at those and we will have final action on House Bill 2490. With that, then, a brief reminder from the reviser. This would define what the court, when it can extend the detention time for a juvenile. We last year, when we amended the law, we didn't say, well, how long could that extension be? And the bill provides up to 90-day extension at a time. But the reviser will briefly remind us.
Thank you, Madam Chair. Jason Thompson, Revisor's Office, and you're correct. This does explain what the legislature enacted last year as extensions of the overall case length limit. Clarifies that not only can those be granted incrementally, which is what you said last year, but that those increments shall not exceed 90 days per extension. That's the new change.
Thank you. Questions for the reviser? Not seeing any. Then is there discussion? Senator Corson.
Thank you, Madam Chair. I have some amendments. They, in just full transparency, they were drafted by Senator Baumgartner along with Mr. Thompson. And so I'm going to offer them with her permission on her behalf. Just want to be completely transparent about that. She has discussed them with me, but I haven't actually seen them in writing. So.
Oh. Yes. Do you know which one you want first, Senator?
Let's start with the literacy assessment. Madam Chair, I'm sorry. We are now well beyond. So I've missed 2 meetings. I've got people waiting for me, but this is more important.
We are concluding our work today so that committee does not have to convene tomorrow. So appreciate everyone's indulgence with running over our allotted time and for staff hanging in there with us as well.
Madam Chair, what this amendment does is it requires an evaluation of the juvenile's academic records. The request is that the Jobs for America Graduates Kansas Administrator will aid in determining the juvenile's educational needs. The reason I am requesting this and that I think it's important for this is as children are, and let's be clear, these are children, as they are being confined, they are not staying up with their coursework. And so it would only be appropriate that someone evaluate. And the reason I am asking for the JAG-K administrator to do that is because they currently do that here in the facility that is in Topeka.
Thank you. Committee, any questions? Is there a fiscal note attached to this? Do you know?
I don't believe there is a fiscal note. It would require perhaps all of about 30 minutes to evaluate.
Because it's the JAG-K people who would be doing the assessment. Committee,
Yes.
any other questions? Not seeing any, then do you want to make a motion, Senator?
I move my motion, my amendment.
And a second from Senator Gossage. All those in favor signify by saying aye. Those opposed, no. The motion carries. We are back on the bill as amended, and I believe there's another proposed amendment.
I have several other. The next one has to do with the literacy evaluation. Thank you. Excellent. Congratulations. Madam Chair, I'm happy to explain this amendment.
Go ahead.
What we do know is that currently in our corrections facilities, 7 out of 10 to 8 out of 10 of the individuals that are in our correctional facilities are illiterate. They cannot read. What we know in our schools and in our classrooms is that oftentimes the children that are causing the most commotion and disruption as far as behavior issues are those that likewise cannot read at grade level, which means they cannot read above the level of 3rd grade. So what this does is simply indicates that a dyslexia screening by a member from either the Center for Reading at Pittsburgh State University or the Phillips Fundamental Learning Center, which is located in Wichita, Kansas, be performed, and that a reading level assessment to aid in determining the juvenile's educational needs would be performed. The reason I cite those two centers is that's where children within the state go now for that assessment if they were not screened in their kindergarten, 1st or 2nd grade.
Thank you. Committee, any discussion? Senator Gossage.
Yes, Madam Chair, I believe that there are other centers that do this. I know when my son was diagnosed, I took him to a different center. So I'm just not sure, depending on where the juvenile is located, that having somebody go there from Pittsburgh State University or Phillips Fundamental Learning Center, and perhaps the wording could be changed to say someone certified to be able to do a dyslexia screening instead of indicating a particular entity.
Thank you. Other discussion? Senator Baumgartner.
Yes, my only response would be that they are able to do this virtually.
Any further discussion? Senator Baumgartner.
I think at some point in time this would be amended because a part of the Kansas Blueprint for Literacy indicates that we would be adding up to 6 additional centers specifically for dyslexia screening and training. And so as those become more regionally available, they would be done. The reason also that I included Phillips Fundamental is because a lot of what we heard from with regard to testimony had to do quite specifically with what is the juvenile situation, the higher incidence of those are specifically in Sedgwick County. Thank you, Madam Chair.
Thank you. Committee, further discussion? Not seeing any. Do you want to make your motion?
Yes, Madam Chair, I move my amendment.
Is there a second? Senator Corson. All those in favor signify by saying aye. Opposed, no. The motion carries. We are back on the bill as amended. Senator Baumgartner.
Thank you, Madam Chair. Part of the concern during the hearing was there weren't guardrails as to the limitation of the number of times in which extensions could occur. So I actually have 3 amendments. They are very similar, but what they do is they change how many days we're willing to let them continue to be. And let's be clear, I mean, they're being incarcerated. So how long we're willing to have them be held while they continue with their treatment. So I'll start with the first one and let's do it with the 90 days. It's okay. We could have just gone with that. Yep. Yes. So as they're passing this out, on page 2, it simply says that the court may only extend the overall case length limit 2 times, and each extension shall not exceed 45 days. So that would be no more than the 90 days. But they could extend it at 2 separate times. It could be less than the 45. It would be at the court's discretion.
Committee, I think this amendment completely undoes the bill, if I'm reading that correctly, because I think the bill provides extensions of the overall case length shall only be granted incrementally and shall not exceed 90 days per extension. So this basically undoes the underlying bill. So just to note that, if I have that correctly with the revisor.
Madam Chair, Jason Thompson, Revisor's Office. I don't know that I could say exactly what you said, but I will say that under the bill, you are allowed to extend incrementally in 90-day increments, but there is no limit to the number of extensions. And the bill would put in a 2 extension limit of 45 days each, so a total of only 90 days.
And the strike throughs kind of above the balloon, those are part of this amendment. Is that correct? The strike through of the italics?
Yes, Madam Chair. The strike of extensions through extension period in lines 29 through 31. So this would replace the general extension language with the specific 2 extensions, 45 days language.
And I think the testimony wasn't, I don't think, that there should only be one 90-day extension. And so the amendment would make it so that it could only be up to 90 days. And to me, it significantly changes the bill that passed. What was the vote in the House? 120-0 in the House. So any other discussion? Senator Baumgartner.
Yes, Madam Chair. If you look at what is striking, it says extensions of the overall case length limit shall only be granted incrementally, and that the extension shall not exceed 90 days per extension. What this really says, what was amended and put into this bill that was passed by 120 votes, is that the courts can continue to extend and extend. There is no limit to the number of extensions. There's no limit to the extensions, and this is putting a limit that there would only be 2 additional extensions, and they couldn't exceed 45 days each.
Did we have any testimony that was saying that well, I'm finding that without further testimony about why we need the extensions and if the court deems it in the best interest of the juvenile to make the extension, we have the courts looking over and determining, is this extension to be granted or not? And the court can use their discretion to determine if, as the underlying bill says, shall we extend the overall case length so that the juvenile who is perhaps just waiting out the running of the clock for 90 days under this amendment can be extended on their case length so they actually work the programs that they are in while they are working their case length, which was the purpose of what this body passed last session to make sure that our juveniles were getting their cases worked and receiving the services that they needed while there. So this to me is a big change in the underlying bill that again passed the House 120-0. Thank you. Are there any other discussions? Yes, Senator Haley.
An extension of what you are saying, Madam Chair, and thank you. I know Senator Baumgartner is active with the Joint Committee, the Corrections and Juvenile Justice. Was there this discussion for limiting the time limit? If she would share with us if you've had part of that discussion during committee deliberations for the length of time, Madam Chair, and what was the outcome if it were discussed on that joint committee?
Madam Chair, if I might. Madam Chair.
I'm sorry. Yes, go ahead, Senator Baumgartner.
We heard testimony not only this session, but in prior sessions that there is actually no documentation that says extending for periods of 90 days or more is of any benefit to a juvenile. In fact, it's detrimental to continue to extend. And I would further say that, now think about this, the court can repeatedly extend at 90 days, 90 days, 90 days, no limit. And 2 of those extensions eliminates an entire school year. So, part of the reason that originally when we worked on this bill last year, it didn't pass out. This is a very contentious bill. I think if you were to go back and look at the floor debate on the House that garnered the 120 votes, you would find it was very limited discussion, and some of what was shared was misleading. I received text messages from individuals that have testified before, not only in front of the Joint Corrections Committee, but before this committee, that what was being shared on the House side was not in fact factual. So if the concern is that 90 days extension is not sufficient, then we can drop this and we can move on to the next recommendation or the next amendment, if that's the wish of the chair.
Thank you, Senator. Are you withdrawing your amendment?
I'm happy to.
Okay. Thank you. You have another amendment?
I do.
Senator, do you want to explain your amendment?
I do, Madam Chair. I will remind the committee that at no point in time did anyone testify that allowing the court endless opportunities to extend case length, not to exceed 90 days, but unlimited, would ever get us to a resolution. So what this does is the court may only extend the overall case length limit 2 times, and each extension shall not exceed 60 days. So that is a total of an additional 120 days, of which the court can extend. I think we can all agree that 120 days is a lot of time. And I would simply say that at some point the court needs to recognize if they can't get this done within the 120 days, then a different course of action is needed. Thank you, Madam Chair.
Question for the reviser. In these juvenile detention cases that we're talking about, and the court determining whether there shall be an extension of the overall case length limit, is each juvenile represented by counsel?
Thank you, Madam Chair. Jason Thompson, Revisor's Office. I recall from our juvenile fines and fees bill discussion that yes, you can have an attorney in these proceedings, and then there's provisions for who pays for that. I can't remember exactly how it works, but yes, you do have a right to counsel.
Okay, so the juvenile will have an attorney there representing him or her to the court to argue if the case length extension is not what the juvenile, they can make their case to the court, and the court can decide whether the overall case length limit shall be extended or not. So again, to me, this limitation significantly changes the underlying bill, and in essence, it's no longer the underlying bill with the amendment. For other discussion, Senator Corson.
Thank you, Madam Chair. I'm going to support this amendment because this is really an outgrowth of what we passed last year in 2021. And if you recall, 2021, it was very controversial. It barely made it out of this committee. It then failed on the Senate floor the first time. It was then brought up on a motion to reconsider, and it passed with 21 votes. So there was a bipartisan group of folks who had very significant concerns about 2021. And I think what Senator Baumgartner's amendment is meant to address is the fact that part of the testimony in 2021 that we heard was that there was no guarantee that these juveniles were receiving the services. And so you had folks who were actually just being detained and they hadn't completed the program because they hadn't received the services, not because of any fault of their own necessarily. And again, there's no empirical evidence that these continuing case length extensions provide any sort of a better outcome. So that's the testimony I remember. And what I think this amendment will do is it will light a fire under the feet of the providers to make sure that these juveniles are getting the services in an expeditious way so they can complete and move on with their program. So I'm supportive of this amendment. I'm glad it's being brought. Thank you.
Committee, other discussion. Senator Gossage.
Thank you, Madam Chair. I'm trying to understand in the paragraph, this is talking about juveniles on probation, right? So they're not actually locked up during this number 2, or are they?
That's a question for the revisor. So they're not in detention, these case lengths, so they then wouldn't be missing any school? Because these are just for extensions of probation and your case length to work your case while you're on probation?
Thank you, Madam Chair. Jason Thompson, Revisor's Office. So my recollection and reading this again, you are on probation and you're trying to complete your programs, and that is when your probation can be extended. And rather than running into the case length limit and having to stop the case, you can extend the case length limit to allow completion of those programs based on certain findings. So yes, I think you're on probation at this point and doing your programming, and you're not at JCF or something like that.
For that reason, I would again assert that, you're not missing a school year, you're on probation. These are for services while you're not being detained, and it would be a significant change of the underlying bill. Yes, any other discussion? Senator Baumgartner.
I will simply say there is no guardrail with regard to the extensions. There is no guardrail. And since they are on probation, they would be at some point in time for anything could be found in violation of probation. So that's part of what, as they extend the probation, part of the testimony was that then they get in trouble because they're still under probation, because they haven't completed a service, the service hasn't been provided by the local provider, and then they end up back in detention for violation of probation. So we can continue to kick the can down the street, and that is what this underlying bill allows. Shall not exceed 90 days per extension, which means multiple extensions. There's no limit to the extensions.
Senator Wilborn.
Thank you, Madam Chair, and thank you, Senator Baumgartner. I know you're passionate about these issues, and I'm frankly caught cold, and I'm now refreshing myself a little bit. Is there another way to put at the end of 2 extensions a review process to, you see what I'm trying to get at, as opposed to?
Oh, absolutely. And there's, Mr. Vice Chair, there is this assumption that the youth, the family is going to be able to get an attorney to represent the youth. So would love to have a review process. It's not in the underlying bill. That is the problem with the underlying bill. What it does is it allows the courts to continue to extend. That youth never gets out of probation. What they're likely going to do is get back in to the juveniles. They're going to stay in the juvenile system until they age out.
Madam Chair, may I appreciate your comments. Is there a way we can fix that without closing the gate after 2 60-day extensions with the expert review that's automatic? You see what I'm getting at?
I see what you're getting at, but I know what the courts do. Madam Chair and Mr. Vice Chair, the courts will continue to read what it says, only granted incrementally and shall not exceed 90 days per extension. That gives them permission to continue the extension ad infinitum until they age out.
Committee, I'm going to ask, is there a motion on the amendment?
I move my amendment.
Is there a second? A second from Senator Corson. Any further discussion? Not seeing any. You all have heard the motion. All those in favor signify by saying aye. All those opposed, no. The motion carries. We are back on the bill as amended. Are we done with amendments? We have one more.
Madam Chair, I move we pass out House Bill number 2490 as amended.
Yeah.
Oh, I'm sorry.
No.
Sorry, I didn't mean to deprive you.
Not at all. In the nature, Madam Chair, and if you want
I'm not asking for it to be passed out. I want to know what it is.
It's regarding the restraint or prone restraint, barring prone restraint for juvenile offenders.
Committee, we are far past our time, and let's stick to the subject of the bill that we are working. So with that, Senator Baumgartner, do you have a motion?
My motion was simply to move out House Bill number 2490 as amended.
Committee, is there a second? I'm not seeing a second.
I'll second.
Second from Senator Corson.
Discussion.
A discussion, sure.
Madam
Senator
Chair,
Haley.
I do support the bill as amended, but I should say that there will be some other issues that should this bill, and I hope it will come before the line, that the committee be aware of regarding prone restraint. We have some serious cases, and this bill directly does address the conduct of juveniles that are held in custody and how that is. And I will be having to discuss that as this moves. I would prefer to dispense with it here. I do know the hour is late, but the amendment has been prepared and it has been drafted and should have been discussed. But I do know the hour is late. I support the underlying bill as amended, but there needs to be further discussion into the conduct of juveniles. Thank you.
Thank you. Discussion from Senator Gossage. Senator Baumgartner.
Thank you, Madam Chair. I'd just like to make the point. My preference would be that we take no action on this bill and that it just die. But I think it's important that we pass it out so that at least we have, this is the committee's position. Should it get above the line, it is the Senate's position as amended.
Right, if it gets above the line and proceeds. And yes, committee, do we have further discussion? Not seeing any, then you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. Then thank you for everyone for your work this session, and for staff and everybody else. Thank you. And with that then, Committee, we are adjourned.